join me on another edition of Law and You. My name is Philip Omo-Gyupon, and today we're going to be looking at issues about succession as it relates to rights, inheritance rights, and we're going to be also delving into the widow's rights, if they have a place, looking at the legal system of the country. Discussing this with me is Ahigbe Oserago. Good to have you join me, Ahigbe.
Thank you, Mr. Philip.
Now, first, let's look at what succession is.
Okay, well, succession in a layman's terms is transfer of property from one individual to another. So succession, as it relates to inheritance, is the disposition of assets of a property owner in his lifetime to the persons he wants to acquire those assets when he's no more. So you can do that through various vehicles. You can do that through a will. You can do that through creating a trust. You can do that through creating a deed of gift. In fact, there are diverse ways through which you can, transfer assets in a person's lifetime to another person, either while the person is alive or when the person has passed on.
Okay, let's look at the widow's rights, for instance, because I understand that if there is a testate, that could also bring in some respite, but if there is intestate, that's another challenge. So where is the place of the widow, looking at the rights of widows in this regard?
Okay, so when we talk about testate succession, that simply means that during the lifetime of the individual, he wrote a will. So that will comes into force upon his demise. Intestate succession means that during his lifetime, he did not write a will. So he died intestate. So upon his demise, his property will be distributed in accordance with the terms of his will. Because in that will, he would have appointed executors. Those are the persons that will carry out his wishes the moment he passes on. Now, when he dies without writing a will, his property will be distributed in accordance with either native law and custom or in accordance with the administration of estates law. Now, it's a bit complicated, but I'll try to break it down.
Okay.
So, when a man dies, his widow is faced with a lot of sociological, psychological issues.
As we experience this in Africa.
Of course. So, the first thing that, under native custom, the first thing she's subjected to, she's going to be asked, come and tell us what killed your husband. Now, so, under that situation, the law frowns at forcing her to say those kind of things, so they make her to...
As in to give an account.
To give an account.
On that.
Yeah. They force her to take some oaths, they make her drink some fetish processes. The law frowns at it. It is a violation of her right to the dignity of her person. Now, but what are her rights upon the demise of her husband? This is where we find some very serious complication, especially for the widow.
Okay.
Now, if she contracted a marriage with the deceased in his lifetime under native law and custom, the property will be distributed according to the terms of native law and custom.
Okay.
Yes. Under native law and custom, which is most unfavorable to her, most of the customs in Nigeria today, they view women as part of property to be inherited. So under native law and custom, she is part of the assets to be distributed. Although the courts have held in so many cases, they've declared some of those customs repugnant to natural justice, equity, and good conscience.
Though they still exist, they
still practice it. So if she contracts a native law marriage with her husband, chances are that she may be distributed along with his estate. But remember I told you that if the man writes a will, his assets will be distributed in accordance with the terms of the will. Now, but the problem that will arise is when he did not write a will, he did not create a trust, no succession plan, his property will be distributed in accordance with the administration of estates law. That is, if the lady and the deceased contracted what is called a statutory marriage.
Okay.
Yes. So if she contracted a statutory marriage with the deceased, Section 49 of the administration of estates law says that she's entitled to his residuary estate. The residuary estate means after you've settled his creditors, after you've paid for the funeral rites and all that, and all sundry bills, the residuary estate is what remains. She's entitled to it because she contracted a statutory marriage.
Okay, but we need to break it down, like
Yes.
you made mention of the statutory marriage, you know, in simpler terms for our viewers' benefit. What do you mean?
Okay, that marriage that commences from the marriage registry,
Okay.
they give you a form, you take it down to the church, a licensed place of worship, and then you celebrate the marriage in a registered place of worship.
Okay.
That's the statutory marriage.
Okay.
So if she contracted that kind of marriage with the deceased before his demise, she's entitled to his residuary estate, even if he didn't write a will.
When you say residuary, what do you mean?
So residuary means after you have paid the creditors, the deceased creditors,
Okay.
after you have paid for the funeral rites
The
and all those
expenses,
expenses,
and what is left.
what is left, she's entitled to it. If she did not have a child, with the deceased, she's entitled to it. Now, the second layer is that she's entitled to 1/3 of his residuary estate if the deceased had maybe father, mother, brother, sister, and she had a child. Remember, the first one, no child, she takes everything. The second one, she has a child with whether the deceased had father, mother, brother, sister or not, she's entitled to 1/3. Now, the third layer is where the deceased, she had a child with the deceased, right? But father, mother, brother, sisters, parents, she's entitled to 2/3.
To 2/3.
Yes. So what does this tell us? It tells us that the nature of marriage a lady contracts with a man in his lifetime
Determines, yeah.
determines what she will be entitled to upon the demise of the deceased if the deceased died intestate.
Intestate.
So let's go to the flip side. Under native law and custom, she is not entitled to anything, especially when she does not have a child. So she can only claim through her children. But again, what the family of the deceased would normally do is to allow her remain in that property, that's the dwelling house, maybe the house the deceased built before he died. They allow her to remain in that property
For some time.
during her lifetime.
When you say for some time, there's no duration?
During her lifetime.
During her lifetime?
Yes, but she cannot sell. She cannot sell. So they allow her, and then her staying in the property must be subject to good behavior.
Is this under the native law custom?
Under the native land custom.
Okay, but do you also agree, because there is this issue about igogbe, you
Yes.
know, when it comes to that.
Yes.
At what point, what portion does such a woman enjoy? Are you including the igogbe as part of it?
No. In fact, under Benin native law and custom, once the issue of igogbe is a notorious legal issue, the igogbe goes to the eldest surviving son.
Okay.
So she has no part
In that.
Now, the issue about the rights of a woman who contracted a native law marriage is very complex and unfavorable to her.
Yes, of course.
In one of the cases, Oji and Oji, the lady had a misunderstanding with one of her sons. And remember I told you that she's entitled to remain in that property subject to good behavior and for her lifetime. So because she had a misunderstanding with one of the sons against the other siblings, the son issued a quit notice to his mother and said, leave the house. The matter went all the way to the Court of Appeal, and the Court of Appeal said, you cannot evict her from the house because she has a life interest in that property. Right? So, but you see, Why go through the hog of not writing a will and subjecting a widow to face the vagaries of native custom?
That's the consequence when you don't write a will.
Yes. And then subject her to the unfortunate situation of pursuing letters of administration, because you see, the disputes relating to these issues is over property. If there were no property, there won't be disputes. And if the deceased was not wealthy, and if he didn't have assets here and there will be no dispute as between the widow and the family of the deceased. So it now boils down to the deceased to ensure that he does everything possible, legally possible, to protect the interest of his wife in his lifetime.
Yeah, in his lifetime.
Yes.
As in the time he is alive.
At the time
of his.
Yes.
Okay.
Yes.
Now, let's look at this challenge where, because you made mention of the children, under native law and customs, where, the widow can also benefit.
Yes.
A situation where she has female children, for instance.
That's another very complex situation. In some customs, she is not even allowed to stay in the property because she didn't have a son. In some customs. While in other customs, they are not particular about, male or female. Their concern is that as long as she has a child for our brother, we should allow her to remain in that property because of our child. So the reason why she is even allowed to remain in the property subject to good behavior is because of what they call their child.
Yes.
But you see, under the Oka native law and custom, there's a matter that got to the Supreme Court where the Supreme Court said, you cannot deprive the woman of remaining in her husband's property on account of the fact that she did not have a male child for the deceased. That custom is repugnant to natural justice, equity, and good conscience. And IT Mohammed JSC made this very clear. And he said, we cannot dictate the gender of a child. We can't tell whether this will be male or female. So why are we playing God? Why are you trying to take control of what in the real sense you cannot take control of? What is most important is that the lady has a child, her husband has passed on, she must be catered for. So you see, the challenges we have in society today is that we do not have laws, state laws as it were, except for some states like Rivers State and Enugu.
Okay, that have broken through that jinx.
Yes, they've broken the jinx. They've made laws to say that a woman can inherit her husband's property. A daughter can inherit her father's property. But generally, under native law, the right of the woman to her husband's property is channeled through her child. So you now see other customs where she doesn't have a child, or she has a male child, or she has a son. But you see, we've emphasized the problem. These are the challenges. These are the drawbacks. What is the solution?
What is the solution?
The solution is as simple as possible, as simple as ABC. Create an estate plan. Write a will. Set your affairs in order.
In your lifetime?
In your lifetime. Because if the deceased writes a will and he defines, well, when I say write a will, properly written at that, because there are wills that can be challenged.
Oh.
Yes, for want of testamentary capacity, certain prerequisites were not followed.
Oh.
So a properly written will would inevitably protect the widow from any form of issues when the man passes on.
Okay, well, I think I have to probe into this. Or what, in your mind, or in your concept, can we say is a properly written will?
So, under the will's law, it says the will must be written. The testator, that's the person writing the will, must have testamentary capacity. the man must be of sound mind.
Okay.
You know, so you shouldn't have influenced him to write the will. He should have been in his correct state of mind. Yes, when he wrote the will. You know, he should have witnesses, those who will witness that really this was what he intended to achieve. He should have executors, those who would execute the terms of the will when he passes on.
Okay, when you say, before you go on, for witnesses, what's the yardstick?
I was there when he signed. Anybody?
Okay.
I was there when he signed, and the witnesses will sign along with him. So you're not saying he signs today,
okay,
and then the other man comes next tomorrow to come and witness. No, they all witnessed his signature to the will. Right?
In a situation where the persons that appeared as witnesses, as at the time of executing the will, they are no longer alive.
Well, the witnesses to the will, there's nothing that says that, no, of course, they cannot, nobody has eternal,
yes.
Yeah, so if they passed on, that's all well and good, but there must be somebody to confirm that indeed these people witnessed the will.
Okay.
Those witnesses too may have their own executors and their own wills, right? So the principle is a bit complex, but let me try.
Okay.
So the person who executed a will, for example, his own executors can be called upon to stand in where there is a situation.
Okay.
Yes. So, but the idea of a will is that it begins to speak from the grave. The moment the man dies, the will starts to speak.
Okay. Before we go further, because like you said, it's a bit complex, and we need to, break it into simpler forms. Who are the executors? What are the requirements?
He picks whoever he chooses.
Okay.
A minimum of two. So they ensure that what the testator, that's the writer of the will, intended is carried out. Where they face some challenges, they have there are issues they need to sort out, the High Court of the state has the jurisdiction to guide them. They can go to the High Court and say, oh, we are having this issue, or one of the executors passes on, and then there's a sole executor. He can go to the High Court and say, you know what, please, we would need the court to appoint an additional executor to allow me function. So the High Court plays a supervisory role over the functions of executors. Their role is akin to that of trustees, just to ensure that what the testator intended is fulfilled.
Okay, let's look at writing a will, for instance, because some are scared that, by the act of even writing a will means that their death is close, their demise is close. And there's these beliefs, that go with it. Now, what do you see, what's your advice, in terms of encouraging this process?
No, it is, you see, all the cases relating to widows' rights we talked about, and most of them emanated from the eastern part of Nigeria. All those cases we've talked about arose from disputes over property. Now, so there's nothing that says that when a man writes a will, it means that he's going to die the next day. No.
And when should a man write the will? Is it when he has property? Or, because some will also say that, what's the point of writing a will when I don't have, when he or she doesn't have
you can determine through your will who takes over your Facebook account. You can determine through your will who takes your shoes, your personal chattels, your movable assets, your immovable assets, even as much as
your future establishments.
Well, future is not in existence at that time, right? You can determine who takes what. You can determine who takes your shares in the bank. You can determine who takes your clothing, your car, in a will. But you see, I must point out that there are various ways, various vehicles through which you can transfer assets in your lifetime to a beneficiary upon the demise of the deceased. You can create a trust.
Okay.
So, you know, like you mentioned, the Gilbert thing. So a man has an asset, or he has an asset. Upon his demise, a Benin man, his eldest surviving son takes over the asset, right, to the exclusion of his other siblings.
That's the topic we need to treat in the next future.
That's fine.
Okay.
That's fine. So let's keep it.
Okay. So now let's look at a lot of women, who are widows, who are victims, because they don't have the wherewithal, who are in this challenge and they want to express themselves. They want the laws, the legal system, to come and bring respite in their way. What's your advice for such?
Now, so the starting point is the nature of marriage a lady contracts with her husband, because of course the lady cannot compel her husband to write a will. So we're speaking for the woman now, okay, right? The nature of marriage you contract with a man determines your right or interest in his assets or his estate upon his demise. Like I said, under native law, she does not have an absolute right. She only has a living interest in that property. Okay. If she contracts a statutory marriage, and I explained what a statutory marriage is, she's entitled to either the entire residual estate, 1/3 or 2/3, depending on whether she has children for the deceased or not. That is as it relates to the lady. But I must quickly say that those customs that still consider women as part of assets to be inherited is barbaric.
Yes, it is. It is.
It's barbaric. I read a case, Idubo and Emokpai. I think it got all the way to the Supreme Court. And the lady wanted to apply for letters of administration over her late husband's estate. Now, she knew that under Benin native law and custom, she cannot inherit her husband's property. So she applied for letters of administration as a protector of her children. Her in-laws challenged it in court and said, you contracted a native law marriage. Therefore, you are not even entitled to letters of administration. The Supreme Court said no. She's not applying for herself,
but for the children.
At the end of the day, the major consideration should be for the widow, her welfare, her well-being, because she has just lost her husband. You know, the sociological, psychological, emotional issues involved. What the family of the deceased should do is to ensure that her interests are adequately protected.
Thank you very much. I think we're going to leave it at that. Big thanks, Barrister Akigbe, for taking our time to be part of this as well. We're going to be on succession series as it relates to inheritance rights for some time, coming, and we're going to be engaging Barrister Akigbe in all of this. My name is Philip Omo Gyupon. We'll see you on the next one. Goodbye.